Thank you for having us here. I am Meredith Badler, Program Director at CBCA, which does stand for the Colorado Business Committee for the Arts. So we are a 33-year-old nonprofit organization. We're based in Denver, but we actually do work statewide and are looking to do a lot more work statewide. So hopefully that acronym will become very familiar soon. And our mission is to connect business and the arts with business to advance the creative economy of our beautiful state of Colorado. We do a lot of things at that intersection of arts and business. We do advocacy, we do research, leadership training, volunteerism, and arts engagement, again, across arts and business. The program I'm here to talk about, though, is called Colorado Attorneys for the Arts. This is about a almost three-year-old program that we've been running at CBCA. And Colorado Attorneys for the Arts, or CAFTA, it's the very lovely acronym that we use for it, is a pro bono legal referral service. So we serve essentially as a matchmaker to connect income-qualified artists, cultural nonprofits, and creative entities with volunteer attorneys willing to provide their legal services free of charge. It's an incredible service. We are so lucky in Colorado to have a number of attorneys that want to give their pro bono time to support the arts, and they do that through us. I have some business cards with our website, which has oodles of information about how you apply for a referral, as well as that application. They're up at the front, as well as some notepads from our annual Business for the Arts Awards, and you can sign up for our mailing list. We'd love to get you involved in that program and help you out now or in the future. Please tell your friends that that's there and available for you. In addition to that referral service, we offer workshops like this all the time. You just have to call. Becky called and we said yes. And then I called one of our fantastic volunteers and said, hey, can you come up and talk about intellectual property and contracts and licensing and all the things that we know creatives need to know. And we would love to be able to offer that to your organizations, to your friends, to anyone who wants to have that information. So that's one of the things we do at CBCA to connect arts and business. That's why we're here today, is this fantastic CAFTA, Colorado Attorneys for the Arts program. And with that, because I am not a lawyer, I just have the pleasure of administering that program, I will introduce your speaker for the evening. Dave Ratner is with the Creative Law Network. He's been working in the arts and entertainment field as a creative professional as well as an attorney for many, many years. He has a particular knowledge in the music industry, but really can speak on all of the different arts disciplines and the legal issues that are related to those. So with that, I'll bring up Dave.
I'm a little bit taller, but I'm actually just gonna... I tend to wander a little bit. Thank you all for being here. This is really fun for me, and I hope it will be enjoyable for you. The thing about this is, I'm not up here to lecture. I'm up here for you. So the more this is a conversation, I think the better it is for you. Certainly the better it is for me, because it means I'm talking about what's relevant for you, right? What's interesting for you and what you need to know. So you're absolutely welcome to ask questions throughout this entire time that we're talking. Shout out, raise your hand, whatever works. We are being recorded. I do have to repeat any questions or we'll pass around a microphone. But just so you know, if I'm repeating things you said, it's not because I didn't hear you, it's because someone has to hear it later on. I'll tell you a bit about myself because yes, I'm an attorney. I'm also a recovering band manager. Before that, I was a tour manager. So I basically, you know, I was 20-something and working in an office job. It was actually, I had a good office job for my 20s. And I was someone who, especially at that age, really wanted to do something I was passionate about. And I certainly wasn't passionate about sitting at a desk all day, building websites for people that I didn't know. And so I quit, and I said, what am I passionate about? I'm passionate about music. I called up my favorite band at the time. I said, I want to work for you. They said, well, you could like make sure our CDs are in stores in the towns that we're going to play in. You guys remember CDs, right? Seen those? And I said, that sounds great and all, but if I'm going to work for you, I want to do this full time. They said, well, come out on the road with us. So I got on the bus and was selling T-shirts and CDs and hauling gear and setting up microphones and driving the bus. And I slowly, after 6 months, they're like, all right, you're now our tour manager. So I became their tour manager and started planning the tours. And a few months, as I did more and more, I became their manager and eventually got off the road and set up a management agency, started managing other bands. But all this was about helping these artists, right? I was working for these musicians who wanted to make music. They didn't want to respond to emails, right? They didn't want to worry about whether their CDs were in stores. They wanted to make music. And it kind of got this idea in my head that, these artists, because some of you said I'm not an artist, I can't even draw stick figures. Like, you don't want me as your artist. But I can write contracts, I've discovered. And so I found that my value to the arts was helping other artists. So after being a manager for a while, I realized these musicians need a lawyer because there aren't any. There's one lawyer in the state of Colorado that I knew who's lovely, that one lawyer that understood the music business. Lovely woman who I absolutely love. She's since retired and is now a therapist, which is kind of, yeah. So, and so I said, okay, well, I'm going to go to law school. And that is how I am now standing in front of you. I went to law school. I discovered, yes, I'm actually not bad at writing contracts. And this stuff called intellectual property is really fascinating to me. It may not be fascinating to the average person, which would make sense. But how this all works is really interesting. And so I've focused my law practice on law for the creative arts, basically. What that means is we do a lot of intellectual property and business law, contracts, licensing, things like that. So kind of like this entertainment law, which is another word for what I do, is that intersection of the intellectual property, the personal rights, and the business side of things, right? Because if you are taking photographs or making visual art or making music, well, you're probably hoping to make money doing it. There's the business side, right? And a lot of the stuff that we do, I see my job as just protecting artists. Right? You create something, it's of value, we want to protect it and protect you and your interest in business, the business side of things. So, kind of a frame of where I'm coming from. You guys got some handouts. If you didn't, there's some more in the back. This is not a menu. We're not going to go through everything point by point. It is a guide of things that I definitely usually touch on, and I will try and make it through everything. Like I said, if you have a question, please ask me. I want this to be relevant to you. I think the most relevant thing to just about everybody in this room, actually, based on what you just told me, is copyright. So copyright is a type of intellectual property, which I said what I do is intellectual property law. And intellectual property is stuff that you can own, but you can't touch, really. Now, I mean, you can touch a painting, but the property in that isn't tangible. Right, so it's intellectual property, and there's a couple different types: copyrights, trademarks, patents. You may have heard of these other ones. And so copyright is most relevant to artists because copyright protects any sort of creative work. So that can be, books and poems, music, video, sculpture, paintings, and even vessel hull designs is in the Copyright Act. So if you design a boat, you can copyright it. But the value of the copyright is if you own a copyright, you own a set of exclusive rights. What that means is you are the only person who can exercise those rights. So this set of exclusive rights, the right to reproduce the copyrighted work, the right to publish and duplicate the copyrighted work, the right to perform the copyrighted work, the right to display the copyrighted work, and the right to create derivatives, so to create things based on the original. So all these are exclusive rights, which means if you own a copyright, you're the only person who can do these things. And that's got great value, or it should. The idea behind it, copyright is actually in the Constitution. Article 1, Section 8, if you want to look it up and test me. But what it says is we want to incentivize, we want to protect and incentivize people to create. So we protect creations that incentivizes people to create. Because from a business perspective, right, if you're a visual artist and you're thinking, okay, I can create a painting and I can sell it and I can make money off it because I can make prints of it, right? I can make postcards and giclées and all these type of stuff. Well, if it wasn't protected by copyright, anyone could reproduce your artwork. And then it'd be like, well, I'm not really going to make much money off of this, right? So there isn't that incentive to create. Now, as artists, I mean, I know that as artists, we create regardless, right? It's just what we want to do. But as far as from an economic perspective, protecting that is really important. So that's why we have copyright law. And the thing that's important to remember is that the copyright is owned, or rather, whoever creates a copyright is by default the owner of that copyright. So that kind of makes sense, right? If I write a poem, I own the copyright in that poem. The copyright exists as soon as the copyrighted work is created. So we say as soon as you lift your pen from the paper, there is a copyright and you own it. There is copyright registration. I'll talk about that in a little bit. But it's really important to remember that not only do you own the copyright as soon as you create it, but anyone who contributes to a copyrighted work is a co-owner of that work. So music's an easy example. If somebody writes the music, someone else writes the lyrics, we have a song, but it's a co-authored song, right? Two people contributed to a co-authored work. That is usually how we want it to work out, but not always. I mean, one of the things that happens, I have a lot of writers, if you're an author, you may go and workshop your work, right? You may go and ask for input on your work, which is great. It's a great process. However, if someone says, you know, I think the story should take this turn and you should go in that direction, and you go and write the story the way that that person suggested, well, are they a co-author of your work? So these are things to think about. Now, that depends, and I'm not trying to scare anybody, right? But what happens is I frequently get the easy example is with musicians, because you may be a musician, you may have a 4-piece band, for example, you know, keys, drum, guitar, bass, and you want some horns on your next album. So you bring in some horn players, they come to the studio, they record the horn parts, you pay them $50, they go on their way. They just contributed to the creation of your copyrighted work. So they are a co-owner of your work. Now we can sign a contract that says they're not, right? And that's what we do. Well, if you call me, that's what we do. Hopefully that's what you do if you don't call me. But these are things we have to think about. And again, it kind of goes back to what I was saying about I kind of do the business side so the artist can create the art, right? I'm here because I know a lot of you may not be hiring lawyers at the time, but you will still want to know this stuff. And that's kind of the point, is just to understand how a copyright is created, how it's owned, and also how it's exploited. And by the way, exploited is not a negative term. This is just the legal term that we use. When you use someone else's copyright, if you write a book and I publish the book, I'm exploiting the work. I'm just using it. That's just that's the word for it. So that lawyers use. No negative connotations intended. So the thing about, I said the copyright exists as soon as you create it, but there is a registration system. So we have the U.S. Copyright Office, and we register copyrighted works through the U.S. Copyright Office. Anyone can register a copyright. There's an online form to do so. The Copyright Office website is one of the least intuitive websites you will ever encounter. And they know this. I was just at a conference with a whole bunch of people who work at the Copyright Office. They're working on it. They have made some changes. It sounds like some people nodded. You've seen the site before. That they are working on it. But the point is, we have a registration system. And it's important to register. Now, you may say, well, Dave, I have the copyright as soon as I create it, so why do I do the registration? It's a very good question. The reason is, the law says this tricky thing that says the best proof you can have of your copyright is that you registered it. So we believe you that you created this thing, but if you don't register it and you try and go to court and say, hey, judge, this is my copyright, the judge will say, where's your registration? So we need to have that registration. You will still own it. without getting too deep into it, you need to have the registration in order to go to court. But more importantly, well, from my perspective, more importantly, is about what can happen when you're in court. The thing is, I hope none of you ever end up in court on any side of any issue. It's no fun, it's stupid expensive, skip it. But if you create something of value and someone steals it, you may have to go to court. That's unfortunately the system that we have. And what would happen is, if you haven't registered your copyright, when you go to court, you're going to say, Judge, they stole my copyright. I should be paid for my copyright. And the judge will say, well, you don't have a registration, so all I can do is give you what are called actual damages. Actual damages is the amount of money that you would have been paid if this person had come and get a license from you and gone the right route. If you have a copyright registration, you can get what are called statutory damages. Statutory damages are up to $150,000 per infringing act. So that can be a really big difference. I have a client, or had a client, who is a photographer. He really liked taking photography that was Broncos related, which is understandable. A few of us have heard of the Broncos, right? This is a popular thing. So he had a website, and he had all his Broncos type related photography up on his website. And he was walking downtown Denver one day of a Broncos game, and someone was passing out flyers to a party, an after party for after the game, and he took a flyer and was walking down the street and looks at the flyer, and there's his photo on the flyer. And so someone had, gone to his website, right click, save as, he hadn't watermarked anything, stole his photo. We actually kind of thought, well, this is a terrible, horrible thing that happened, but actually the company that's putting this on is a big national company. They actually have money. They really could have paid us for a license. And also, from a lawyer's perspective, they might actually pay my client, which doesn't often happen. So we contact the company that stole the photograph, and I get the other lawyer on the phone, the lawyer for the company, and the first thing he says to me, do you have a copyright registration? Well, no, he takes a lot of photographs, he didn't quite register them all, but it's really our photograph. And you stole it and you didn't have permission, so you pay us. And like I said, without the copyright registration, all he can get is actual damages. Now, they've handed out thousands of flyers, they spent thousands of dollars on this party, and the lawyer said, nah, I'll give you $300. It's not even worth the time to write the contract for them to pay us the $300, right? If he had had the registration, add some zeros, right? So I will say there are tricks to registering copyrights. So like I said, the website isn't the best, and one of the things that often happens is a lot of us create more than one work, and we don't want to pay not that much. The registration fee is $35 to $55, so you don't want to pay $35 for every photo you take, for example, every song you write, every poem that you write, whatever it is. There are tricks to registering multiple works under one registration fee, so it's certainly worthwhile to do that. But there are very specific ways that we can and cannot do that, and so these are the type of things that I often help my clients with, because one of the other unfortunate things about the Copyright Office registration process, it takes a while. They're averaging, I think, 8 to 10 months these days. I've gotten one in three months. That was once. They actually will not answer if you call them and say, hey, I submitted my registration 9 months ago, can you tell me what's up? No, they will not answer your question until it's been 10 months. So it's worth it to get the registration right the first time, because it takes so long. The good thing about even though it takes a long time to do a registration, the copyright is effective as of the date that you submit the application. So if we submit an application today, we may not get it back until next April, but once we get it back, it'll say June 20th, 2018 as the effective date of the registration. So again, it's definitely worth doing. It is worth doing right because for some reason, if there's a mistake on the application, it goes into this like other pile in the basement, and it's 14, 16, 18 months. I haven't gotten an answer to why that is yet, but it's worth it to get it right. So the Copyright Office, there's a lot of information on the Copyright Office website. It's copyright.gov, really simple. And most of it makes sense for the most part, right? The non-complicated stuff, but it's worth it, especially if I'm saying stuff today that doesn't quite translate, or you think, well, this doesn't exactly apply to me. They have publications on for photographers, you know, for visual artists, what they call pictorial, sculptural, and sculptural works. And so they have different publications for different types of artists. So there is valuable info there. The Copyright Office can be your friend. It's just that you need to go play by their rules. So, yes, ma'am. Did the photographer license the use of the Broncos insignias? So, very good question. He did not use the Broncos like the head, like and the trademarks, because what you're talking about is the trademarks. Well, for him, so what he was doing did not. So they could protect a color scheme specific to what they do to football. He wasn't taking pictures of, he wasn't creating uniforms. So I think that there are ways that they can protect the orange and blue, but they can't prevent you from using orange and blue in a photograph about football. So it's a good question, though. And it actually is relevant even to the copyright side of things, because we can't, for example, use other people's trademarks, brand names, logos, taglines that are of businesses in ways that, that violate their trademark rights. So certainly if you're taking a photograph of you know, the Denver skyline and you get Healthgrades, which is at the top of what used to be the CenturyLink building, which was the Quest building before that. Anyway, so if you get that, you're not selling Healthgrades, you're just taking a picture. However, if you were you know, in the healthcare field and used Healthgrades in a photograph that they weren't involved in, that's using their trademark without permission. So there is definitely important being aware of those trademarks. Filmmakers, this is a big deal. Sometimes if you see a independent film, maybe one didn't have a big budget, they'll be drinking a cola, but it doesn't say Coke or Pepsi. You're like, why is that? Well, because Coke and Pepsi, they didn't pay Coke to use their trademark. They didn't pay Pepsi to use their trademark. So in your creative work, it is important to be aware of trademarks. Yes, sir? Did he have model releases? Yes, he did have model releases from the people appearing in the photographs. They were not Broncos players. So, but yes, I mean, it's a good point for photography and for film. I mean, in anything where someone else appears in your work, it is important to have their permission. Now, if you're, let's say you're a painter and you know, you're painting a portrait, well, for that person, it's kind of implied that you have their permission. But certainly, when there are other people or things, whether it's trademarks or even, you know, even if you're I mean, we don't have a lot of filmmakers here, but it's an easy example of saying, if you're filming at someone's building, you would need the permission to film at their building. So there are these other pieces of the puzzle to put together. Do you have a question? Sorry? Yeah. How much do you have to change something to be able to appropriate it? Just enough. So,
example, because one thing that we were thinking with libraries at one point, you know how they have like, there's no wrong way to read releases?
Right.
We were thinking there's no wrong way to read a book, but then still, we thought too close.
So the example of there's no wrong way to eat a Reese's, or there's no wrong way to read a book. So, couple different things. So, I don't know, is your question specific to art, like?
Yes, more visual arts, because you see like on a lot of the print to order t-shirt websites and stuff, they'll take like Star Wars and something and mix it, or, you know, like in one of my t-shirt designs, I have the Monopoly Man is somewhere in it, but I know that there's sort of a range of outcomes where you can if you change something enough, you're no longer infringing on their trademark or their copyright.
Right, so if you're infringing enough, or you're changing enough, it's not an infringement.
Well, then, like, Damien Hirst one time sued a high school student for using a cutout image of his art piece in a high school collage.
Right, collage work is also different, right? Because, we'll talk about the use of a copyright work. The example of there's not a wrong way to eat a Reese's is actually a trademark. So, because the tagline, essentially, is trademarkable. So we can talk about the library use as well. But for copyrighted work, so for any sort of, whether it's taking someone else's photograph and including it in a collage, making a painting of a photograph, taking a song and changing the words, a few of the words, right? These are all what we call derivative works. So you're basically creating, you have a creative work that is based on an original or somehow taking from an original. Now, back at the beginning when I was talking about the set of exclusive rights, one of the exclusive rights is creating a derivative work. So if I take a photograph, I own the exclusive rights in that photograph, which gives me the exclusive rights to reproduce it or to make a painting of it, okay? That's a derivative of the original. I mean, if you write a book and make a film out of the book, that's a derivative of the original. So there's a lot of this. There is no bright line rule that you have to change it 10%, okay? Unfortunately. There's no easy way to say that, and so people, I get this question fairly regularly, is this okay, right? I changed this so much, is it okay? There's something called fair use. Has anyone heard of fair use? Okay, we've got plenty of hands in the room, great. So fair use means it's fair. This use of this other person's copyright work is fair, it's not illegal. Thing to remember about fair use is a defense to infringement. So fair use isn't something you can say, I'm using this as fair use. It's, I use this, I got accused of infringement, no, it's fair use. It's important to think about because it's something that we actually have to go through the process of proving. So there's actually, there's a test that the judge, that the court will run through to decide whether it's fair use, and there's a few factors. So there's the amount and substantiality of the portion used. So did you use the entire work or just a snippet of it, right? There is the effect on the market for the original. So are people not buying the original because they're buying yours? So these are the things we have to think about in doing an analysis. So it is really hard to kind of say it's okay or it's not, especially because different courts will interpret fair use differently. Honestly, my advice to my clients is if you think it's stealing, it probably is, right? Now, I also think that, I will tell you that I view my job oftentimes, I explain the risk. My client gets to decide whether to take the risk, right? So because some people think they just rather beg for forgiveness than ask for permission. Okay, that's your right, Now, I will certainly tell you if it's flat out illegal and you're going to get sued, but I think there's a good sized gray area in there, so it's case by case.
Kind of back a little bit, but are there any complications concerning the legality of figuring in the fees of a copyright into the cost of the product? So like if we were to do a video, would we like figure in $35?
Can you figure in the copyright fees into the cost of your services? Certainly. I mean, there's no reason against it, and certainly, you get to set your fees, right? So, yeah, and I think, one of the important things to remember, and this, I have a lot of clients who are videographers, photographers, and graphic designers, so you're creating something for someone else. But the thing is, remember, so, in the videography example, right? So we are going to create a promotional video for somebody. In that example, you're creating it. Whoever creates the work is the owner of the copyright, right? So you create it, you own the copyright. Now your client may want to own the copyright because they say, I paid you for it, I want to own it. In that situation, we have to do a transfer, right? We have to say, I own it, I'm giving it to you. And that has to be in writing. So the example I always use, is with wedding photography, because anyone ever here shot a wedding? Oh, wow. Okay, a couple, just a couple, right? Anyone ever here been married? Anyone here married? Anyone had a wedding? Come on, come on. Okay, thank you. So, you know, you hire a wedding photographer, or a portrait photographer, or a baby photographer, and you think, well, these are pictures of my family. I obviously I paid you. It's my family. I own these photographs. Photographer owns the photographs. And it's a really hard one. I mean, people get a little. Well, actually, when I got married, I found a photographer and talking to him, he's explaining copyright to me, and how he's going to hold on to the copyright, and that's fine. I said, you can hold on to the copyright. I just don't want to see my picture end up in a magazine. So we made an agreement that he can own the copyright, but he can't go exploit it without my permission. So these agreements are allowed. We generally, it's licensing, okay? So there are different ways that we can allow the use of a copyright as a copyright owner. So the two main things we can do are to license a copyrighted work or to transfer, assign, give over a copyrighted work. A license is like rental. Okay? So a license is, I took this photograph, I'm letting you use it. Right? I'm licensing it to a magazine for them to put it in their issue. Right? That's a license. But if I take wedding photographs and the couple wants to own the photographs, that's an assignment or a transfer. And a transfer assignment has to be in writing. So the law generally allows for oral contracts, right? So if I'm going to buy your car, we can agree on a price. We'll meet on Saturday. We shake hands. We have a contract. We have an agreement. We have a meeting of the minds, which you need for a contract. We have the terms of the contract, so we can do that. It's a few areas of the law where we need to have it in writing. Copyright is one of them. So any transfer of all the rights in a copyright needs to be in writing. Doesn't have to be a super complicated contract, but it has to be in writing. And there are few certain kind of magic words that need to be in there. It also, if you're granting an exclusive license, so if you're saying to the magazine, you are the only magazine that can publish my photograph, that also has to be in writing. Yes, ma'am?
How does that work when you're in like a designer, a graphic designer who's in an in-house design thing? So I work for the man, and do I own at least a part of the copyright of the things that I create?
So if you're an employee, if you're creating copyrights as part of your job, do you have any ownership in them?
Any sort of contract that says anything that
Totally get it. Yes, if you haven't signed a contract, there is something in copyright law called work for hire. So work for hire is a way that copyright is transferred. And work for hire can happen in two ways. It can be in writing, in a contract, or it can be if you are an employee creating a copyrighted work within the scope of your employment. We don't need a contract. It is just implied that it is work for hire. So in the situation that you work for a company and your job for that company is to create copyrighted works, the company owns the copyrights.
So do I violate the copyright of that copyright if I have a portfolio site of my work that I, like, say I'm trying to find a job?
So, yeah.
If I put that on my website, then I violate that copyright.
If you're so if you have copyrighted works and you're using it as a portfolio, whether to show your work, so if the company owns the copyrights, they own the exclusive rights to reproduce, which means they own the exclusive right to put it on a website. So if you put it on a website, you're exploiting their right to reproduce without permission. Now, like I said, what's the risk? Are they likely to sue you? Is it better to ask for permission or beg for forgiveness? So now, this is not legal advice. Okay? But knowing that I don't expect you to, not everybody here is going to have a lawyer on hand to call. Call CAFTA. If you can't afford a lawyer, please call CAFTA, ColoradoAttorneysForTheArts.org. But the thing is, so portfolio rights are a very legitimate question. I didn't mean to be flippant at all. A lot of times with my clients who are creating any sort of work, we include that. We say we are transferring these rights, right? We will know, the creator will no longer own the copyright, but we reserve a license, right? The owner, the company, is going to license us the limited right to use it just for our portfolio, just for the purposes of marketing and showing what we do. Totally reasonable and totally normal. And actually, in all these different situations, with visual artwork specifically, yeah, very common. But again, you want to have it in writing, because the thing is, I very frequently get the, we're friends, it's cool. Right? He said I can use it, it's cool. Sure, I believe you. But really better to have it in writing. Is an email good enough? It's better than nothing. It's not as good as a real contract. So there's kind of these gradations, but one of the things about kind of the creative process is a lot of us do create with others. A lot of us do use others' work in some way or another, and collaborate in some way or another. I have no problem with that at all. The thing is that when those permissions, when those agreements are oral or implied, and we don't have it in writing, it may work at the time, but memories aren't always so good. Memories are especially bad when you suddenly get rich and famous off of something that they helped you with. Right? So when we are collaborating on something, okay, so we are going, I will go back to the author, the workshopping, creative, or a novel or something like that. You're workshopping a novel, and someone says you should go in that direction, and you go in that direction, and you become a New York Times bestseller. That person may come out of the woodwork and want a piece. They certainly won't care if you never sell a copy. You will never hear from them again if you sell 3 copies. When you sell 3 million copies, that's when they start seeing dollar signs. And this is not an indictment of humankind. We're not all bad people. It's just, this is what I see. Disclaimer here, okay? I see when things go wrong. I'm going to sit here and scare you about all the things that can go wrong. I hope they never do. No one has ever called me and said, hey, nothing went wrong today. Okay? They only call me when things go wrong. So I have a bit of a skewed and therefore cynical view. I don't think people are bad. I just think we want to be protected. Someone's hand went up. Yes, ma'am.
I just have a random question about exposure. Mickey Mouse, right? My art is pretty temporary, and usually made with a temporary product in my industry. I'm a balloon artist, so I mean, literally hot to the second being gone. So I have a lot of people in my industry. They're all like, yeah, we're going to build Mickey Mouse, and we're going to do all this stuff. And I get asked for it all the time, and I don't do it because I respect Mickey Mouse and everything they've done and all that kind of stuff. But I get a lot of feedback from my industry that I'm kind of stuck up, and then I get a lot of feedback from my clients that are standing in line waiting for me to build something. Well, why won't you? Everybody else does it. And I'm like, I think the risk is kind of high for me to build a Mickey Mouse for your kid. So that I just want to know exposure. How much real exposure do I have? Whether it's face painting and little Disney design, which I don't do that either, but even though I have had permissions from Disney directly in the past. I just want to know. I feel like I'm not going to do it for my own personal integrity, but I get a lot of flack from a lot of different parents.
Totally understand. So yeah, but if you're a balloon artist and making, not making balloon art out of Mickey Mouse, or not painting Mickey Mouses on someone's face, you are obeying the law. Yes, so you're not wrong. Here, you are not wrong at all. So creating a balloon version of Mickey Mouse is reproducing a copyrighted work because Mickey Mouse is copyrighted. You're absolutely right. And even painting a Mickey Mouse on someone's face is reproducing a copyrighted work without permission. You're absolutely right. And I think that you are in an industry where things, as you said, are pretty temporary, and therefore people think there's a lot less risk. And I don't disagree that there's less risk than if you were building a permanent Mickey Mouse, but it is still a violation. You know, there's so many, we see so many renditions of famous things that we sometimes forget that they're protected. Not me, but we is the general we. And I mean, I had a client who their business was bouncy castles, right? And they had a bouncy castle that had some comic book figures on the bouncy castle. And DC Comics didn't like that very much. And they spent a lot of money on the bouncy castle, and DC Comics said, I don't care how much money you spent. You cannot have our characters on your bouncy castle. And it's kind of funny because it's kind of temporary because you deflate it, and right? But it was permanent enough. You know, one of the, so you are following the law. And I think the thing is, you're absolutely right to not be tempted to, you know, if everyone else is jumping off the bridge, that doesn't mean you do too. If everyone else is breaking the law, it doesn't mean you do too. I will concede, however, not related to this, but related to a lot of other questions I get. The Copyright Act was last significantly revised in 1976. Things have changed a bit since then. We have these things called computers and phones and really much easier ways to reproduce things, right? So a common example is in music. Okay, mashup artists or just electronic artists in general are using work that's been created before and reusing it in other ways, and sampling. Okay, and collage art has gone a long way because how much all the collage you can do and just Photoshop in general, or you know, digital reproduction in general makes it so that we can do a lot more than we could 40 years ago. The copyright law, I mean, we've had a few updates here and there, but it is still legal to reproduce any copyright work in any way. So the reason I bring up these examples is because the enforcement of the law and the letter of the law are pretty far apart. I don't encourage anybody to ever break the law, but I will tell you that people get away with it every day. I still won't encourage you to do it, but when a musician says to me, can I release this album that is a mashup? Is everybody else doing it? Yeah. Are they getting sued? No. Is it illegal? Yeah. Okay, you decide. Evaluate the risk. So, did you use a question? No. Yes, ma'am.
I was just wondering what you thought about some of the fan art. I just came from Comic-Con this weekend, and what I saw in Artist Alley, a lot of it was Superman, Iron Man, Harley Quinn, Joker, and it's like, so it's people's interpretations, but it's still a copyrighted character.
Yeah, fan art is really interesting. So fan art, you know, like you said, reproducing specifically a lot of characters that are, you know, fictional characters. So some fan art is not legal under the law, but it's promoting the original, and so the owners will look the other way because they say, well, you're benefiting us because you're promoting our, you know, our comic book or our character. There is a use, when I was talking about fair use, one of the ways you can have fair use is if it is transformative. So if you're transforming the nature of that work and using it in a different way. So some fan art is transformative. Some fan art is licensed. They get a license. But there is a lot of potential infringement in fan art, for sure.
But then we go back to Mickey Mouse on your cheek, and that's promoting Mickey Mouse. I mean, everything is so subjective. You can talk your way on each side of every issue. When is it? I mean, and you have to be caught. So I guess it's all up to you and your conscience. Whether musicians that play on a local bar and get paid for it and do all covers.
That's actually a lot. So, but the point is, like, the Mickey Mouse on the cheek is fan art, right? And that's why I said you're following the letter of the law, whether you get away with doing it anyway. You know, I mean, if something is on someone's face for a few hours, are you likely to get sued for it? But no, I mean, and you're right that this stuff is subjective, and it does make it difficult. And we can definitely know what is absolutely wrong and what is absolutely okay, and what's in the middle is one of the reasons I have a job. But the thing is, there also is, I mean, I think, you know, you kind of get it. Here's one of the things I always say to people. if you were the owner of that, would you think it was wrong? Would you be upset? Right? Because if we're all artists and we all create, well, we know what the value of our creation is. And if someone else was using it in that way, is that a problem? And that's not a legal test, but it's a good conscience test. Yes, ma'am.
If we go back to the family, so you were saying you transform art and you use it. Can you elaborate on that a little bit? Because I'm thinking, so for music, if I were to take lyrics from a song that was jazz, and then I would take that and transform it to a country song, is that transforming it enough? Or like with fan fiction, there's a lot of fiction that is being transformed. So Harry Potter, the nature of that story, and then all of a sudden they're turning it into erotic. Is that transforming enough?
Right. Yeah. The guidelines, the kind of the outlines of what is transformative, is a really good question. And we'll talk about music briefly because you mentioned playing music in a bar that's playing cover tunes. Music, I could sit up here and do a whole day just on music, so I won't dive too deep into it. But it is important to know for those of us who are involved in putting on events and just using music in other ways. You can play someone else's music live in a venue as long as that venue has a license. There's something called performing rights organizations. And they license the right to perform music. And whether that performance is playing a CD over a loudspeaker or having a band playing it live, it's still a performance of the music. So every venue, I mean, every bar and restaurant and health club and theater all should have, generally do, have licenses from these performing rights organizations that allow you to then play almost any type of music. It is important, though, I mean, if you are putting on an event, you want to make sure that that event space does have that license, because if they don't, then everyone can get in trouble. Taking a jazz tune and turning it into a country tune is probably, well, you're allowed to record covers as long as you pay a small license fee. So you can record covers, whether it's the jazz version, the rock version, or the country version. You just have to pay a license fee. So it's not really the best example. But the thing is that the transformativeness is, as we said, subjective. So it's hard to provide rules or guidelines for it. Definitely, if you have a parody, okay, is certainly transformative. Right? So you're taking something serious and making fun of it, or making a comical version of it, certainly transformative. Mm-hmm. Well, yeah, I mean, so parody is a good example, but Weird Al Yankovic has been sued. Now, so I can't tell you what he does is always illegal or that it's always okay. It depends on who he's upsetting at the time, right? Yes. So whether mailing something to yourself is a valid copyright. Like I said, you own the copyright as soon as you create it. We can register with the Copyright Office and pay them their fee. Mailing yourself something in order to copyright it does one thing. It supports the Postal Service. No value to it. It's a great myth, and honestly, I mean, Meredith has been here for plenty of my talks. We talk about this every single time. It is the most common myth in copyright. So nothing wrong with having heard that, because everybody has heard that. Just doesn't have any legal value. Yes, sir.
From what I understand, you cannot copyright an idea. And you had a lot of cases where somebody was trying to sue somebody for stealing an idea.
Right, so whether you can copyright an idea, it's a really good question. It is actually one of the first things we learn about copyright, is that we cannot copyright ideas. What we can copyright, in order to be copyrightable, something must be fixed in a tangible medium of expression, written down, recorded in some way. So even if it's typed into a computer, it's in the memory of the computer. So it must be recorded in some way, it must be fixed in some way in order for it to be copyrightable. So we cannot copyright ideas, but if we take the idea and write it down or record it, it is protected. So, and honestly, if I was up here today without this thing or that video camera, what I'm saying, not copyrighted. As soon as it's recorded, then it is copyrighted. And so when we have ideas, people come to me, I got a great idea for a film. Cool, how are we gonna copyright it? We're gonna write down a treatment, or we're gonna write down a script, and then we have something that's copyrighted. And that's how we can protect it. Yes, ma'am.
I'm really intrigued by what you said a little bit ago about if something is a parody, then that's transformative enough. But I can't quite get myself to be completely comfortable with that. I mean, parody is so sophisticated, yes, and some of the most rich kind of genres, I think. But we can't just make a generalization, correct, and say as long as something, a show, a person is parodied or satirized.
Right, so trying to draw some lines around parody is difficult. So the example that we can always go back to, there is a Supreme Court case on parody, and that's what we really defer to as lawyers anyway. It is the case was about the song Pretty Woman, right? So Roy Orbison, Pretty Woman, right? We all know that version. Anyone know the Two Live Crew version? Okay, so does anyone know who Two Live Crew is or was? Okay, not the cleanest act, right? A little controversial in their day. And they made a version of Pretty Woman that was blatantly about a prostitute, which is actually kind of what that Roy Orbison tune was about, but not as blatant. They changed the words a little bit. They certainly had an explicit video, but that wasn't relevant. But the point is, the court considered this, and the court said, is this transformative? They've taken something and they are lampooning it. And that was considered a parody. It was fair use. It was a parody, it was fair use. And so as lawyers, we often look to that case for what was written, and that gives us some guidelines. But I understand it is hard to wrap your hand because every situation is different. Yeah. Now that I tell you how dirty it is, you remember it. Yes, yeah, exactly. Yes, sir.
How does it work with public art? If you're a muralist or a sculptor and you have like a public sculpture and then somebody uses it as like a backdrop or a prop in their advertisement or magazine ad.
Right. So how does public art work? Reproducing public art in a magazine ad or in visual art. So public art is a bit of a different animal because of the copyright ownership, right? So here's something that's very important that is related here is that when it comes to visual art in particular, we sometimes get confused in where the copyright lies. So if you create a painting, a sculpture, there's a physical object, right? And you can sell that physical object. Now, so in example of public art, sometimes, not usually, but sometimes, the physical object is given to the municipality. So the city of Greeley will own the sculpture that you created. Do they own the copyright? No, right? Because they do not own the copyright. They bought the physical item. They did not buy the copyright. When you go into an art gallery and you buy a painting, did you buy the copyright? No, you bought the painting. The artist still owns the copyright. The artist can go make prints. I mean, depending, but the artist still owns the copyright. And the example I give people, again, going back to those shiny things, CDs, if we remember those, when you went to the store and you bought a CD, you didn't own the copyright in the music. You just got a copy of it. So that is relevant to this topic. When you have a piece of public art, if you own the copyright in that piece of art, you own the exclusive right to reproduce it. Now, if it is in the background of a photograph, if it's not the focus of the photograph, is it fair use? Probably is. But if it is the focus of the photograph, the reason that we took this picture is because, or if it's prominent in the photograph, that sculpture is being reproduced impermissibly. And when you think about public art, In Denver, outside the convention center, we have the Big Blue Bear, which you've all got some nods here, okay? So Big Blue Bear. The artist of the Big Blue Bear made a lot of money off the Big Blue Bear. He did not give that copyright away, and you can go in DIA or anywhere else and buy. I've got a little Big Blue Bear in my house. He's up against the window, you know, and he got paid for that. So public art doesn't always transfer the copyright, and so it is relevant to the reproduction of it. Yeah.
Let's say Allison decides to lose her mind and she goes to Disney, and then John decides to take a picture of this child, and he gets permission for a model, but he decides to make it a commercial use, and then Disney discovers it, and they're not happy about this. Who's going to be the one that will likely be behind the trouble?
Okay, so I will repeat. If we put a Mickey Mouse on someone's cheek and we take a photograph of that person with the Mickey Mouse on their cheek and we use that photograph, who's going to get in trouble? Everybody. So here's one thing. Yeah. A little secret about lawyers. They generally are motivated by money. Okay? And so what happens is when we have lawsuits, by the way, I don't actually litigate. I don't do courtroom stuff. So not every lawyer goes to court, and lawyers, what we do is very specialized. But I can tell you, I know this much, that when a lawyer is filing a lawsuit, they're going to sue absolutely everybody they can. Okay? So they're going to sue whoever created the art, whoever took the photograph, the magazine that published it, I mean, everybody, and find the deepest pocket and try and get as many. So, like I said, we want to avoid lawsuits in any way possible. I do want to get to a few more things on here. I'm really enjoying all this. I just want to make sure, because I don't want you to walk out of here and say, what the heck is that? He didn't even talk about that. So, and one other thing that is really relevant to legal protection. You have a question?
Is there a question? No, just a quick question.
Yeah.
You're giving them all the bad news about ways that you lose copyright. Tell them the good news. How long do you have that copyright?
I will not be all about bad news. Thank you for saying so. Yes, copyright term is very important because you own a copyright for a very, very, very long time, thanks to Mickey Mouse, actually, and I can tell you about that. So a copyright exists for 70 years after the life of the author. So when I create a poem today, I own that copyright. I die 30 years from now. That copyright exists 70 years after I die. So 100 years. And there are some variations on that. If it is a work for hire, we talked about work for hire before, it's 95 years after the date of first publication. The reason I say it's thanks to Mickey Mouse is because it was a shorter period of time, and the copyright on Mickey Mouse was about to expire, and Disney lobbied everybody in Congress to extend the copyright term, and so they did. So we now have, Mickey Mouse will expire at some point. I may expire first, but at some point he will. And you know, I do really appreciate you saying it is not all bad news. Like I said, I have a cynical view of things, but really the law is here to protect you. Okay, I mean, the reason we have this stuff is for your benefit, and we can talk about, oh, well, I can't reproduce it because it's an infringement, and that's not a fair use. But if you think about, you probably weren't thinking about this stuff until you walked in here today. And I don't expect you to think about it every time you write or paint or do your creative work in the future. But it's a lot of the questions that I get. Another important thing about protecting ourselves in these creative pursuits is about having business entities that we work through. And so I just want to briefly touch on this because it's something that I talk about with a lot of clients, and I don't want to skip it for everybody here. Basically, a business entity is a company, a corporation, an LLC, a limited liability company. These are all types of business entities. And it may not seem very relevant to an individual artist. You're saying, well, it's just me. I'm just creating my work. Why do I need a business? And a couple reasons. I won't talk about the kind of tax and accounting side of it because I'm not a tax attorney and I don't pretend to be. I will tell you to have an accountant look at your stuff because that's important. But the business entity exists because when you do work through a business entity, that business entity is liable for what you do, not you personally. And this is important because I'll go back to talking about the bad stuff. In the very unlikely event that you get sued for something, we would much rather your entity get sued than you personally get sued. So, I mean, my law firm is an LLC, a limited liability company. And if someone, if someone comes to my office and slips and falls and breaks their neck, and they say there was water there and you were negligent, I'm going to sue you, I want them to sue the company, not me. Then they can take the company's assets, not my assets. And again, it's relevant for creatives as well, because everything we're doing is a business, so why not run it through a business, especially because LLCs in particular are pretty easy to maintain. We file a document with the state, and then we create some internal documentation about the company, and then we're filing we file one filing a year, and we keep our books clean, and we've got a company. And then our company is liable for what we do. And it's amazing how it seems like it's a bit of a pain, but all those contracts you're signing on behalf of the company. And it provides this layer of liability protection that is really valuable if something were to go wrong. The other thing I'll say about entity formation, I have a lot of people, has anyone formed an LLC or a corporation here? Anyone? Okay, so some people have done this. So we've gone to the Secretary of State's website, we've filled out the form, we've paid our $50, and we've filed, and we get something. For an LLC, you get articles of organization. For a corporation, you get articles of incorporation. So we paid our $50. Now we have a company, right? Now we have a piece of paper. And it's important because I get this a lot. I have an LLC. Well, what do you have? Well, I have this piece of paper. How is that a company? And the real world application of this, we file that form, we have our piece of paper. We get sued for something. And they sue us. And we say, no, it's my company, sue my company. And we go to the judge and we say, Judge, don't sue me, sue my company. They should be suing my company. And the judge says, oh, okay, show me your company. I have this piece of paper. It's not very much. So what we do is, what I encourage my clients to do, is to really form a company. We get some documentation in place. So for a corporation, we have like bylaws, which talks about how we operate the company. We have some minutes, like we had a meeting and we decided to form the company and approve the bylaws. We have a bank account, really important. Keep your money separate, right? There's the business money, there's the personal money. We don't go buy groceries with the business credit card, those type of things. And then we've got a much more defensible company. And so this isn't the type of stuff that we often think about when we're talking about law for the arts, right? But we're all artists, and in trying to have a business as an artist, we want to make sure we actually have a business. So that's another kind of piece of the puzzle. Yes, sir?
Copyrights, when you were talking about the term of copyrights, are those transferable through last will and testament? And if they are, does that extend the copyright to the person who receives it for another 70 years past their death, or do they have to?
Is the copyright transferable by will, and does it change the term? So yes, a copyright is transferable by will or intestate. So when you die, it is your property, right? So just like your car, your house, or anything else, it's transferred after you die. It does not change the term. So the term is the same. So it is 70 years after you die for whoever it transfers to. Yeah.
I'm sorry?
The creator. You have the creator, not the person who transferred to.
But now the person you transfer to has permission and authority.
So after you pass away, it is transferred to someone else, and they now own it, and they can exploit it just as if that you had transferred to them while you were alive. So.
That person dies and there's 30 years left on it.
It can be transferred and transferred and transferred, just like any other piece of property. Going back to what I said at the beginning, intellectual property is still property, and it can be transferred just like any tangible property. So just we want to have it in writing.
The information, the guiding principles that may be presented, would they apply to someone in the culinary arts, like someone who creates dishes or beautiful food, art?
Right, so food as art, does it apply to the culinary arts? So usually this comes up in the terms of whether recipes are copyrightable. I said, sorry, it usually comes up in terms of whether recipes are copyrightable, which they're generally not because they're not sufficiently unique. The physical food, I mean, the physical item. So you can't copyright something that is what they call a useful article. So a coffee mug, okay, maybe a really pretty coffee mug, probably not copyrightable. And so the food, I don't know. It's a good question because I don't know if anyone ever has tried to copyright food. My guess is you would be very hard pressed to do so, even though we know that there is beautiful works of art that come in the form of food. My guess, and I'd have to look, my guess is that the Copyright Office would say that's a useful article and not protected by copyright. So it depends. So the recipes can be copyrighted, like in a book, right? In the sense that when you talk about how you do it and the value of it and why your story behind all that type of stuff. If you create a recipe, anyone else can go make that food with that recipe. So if you write down a recipe, I can't go and write it down word for word because that'd be a reproduction. But if it's on a website, I can go make that food and there's not infringement of the copyright. Does that translate?
But you are saying that the originator, the person who created this unique recipe does hold the rights over it.
Do you have a question, Lisa?
What if my medium is ceramics and I'm making mugs?
If your medium is ceramics and you're making mugs. So it is difficult because the Copyright Office, whether a mug is copyrightable, the Copyright Office is going to determine whether it is sufficiently artistic, or whether basically is it predominantly artistic or is it predominantly functional.
So if I copyrighted the mold that's making all of the mugs, then that will hold the copyright?
Copyrighting the mold that makes all the mugs doesn't change the fact that it's functional because it's producing mugs that are functional. So there are examples of functional works that are copyrightable. Again, it's hard to place a bright line here. There's a lot of different examples, and the Copyright Office really does kind of take it on a case-by-case basis. Certainly, I mean, and the Copyright Office, by the way, values art. They're not looking for ways to take away your copyright. It's just that they have to draw the line somewhere. And so they draw that line on what is a functional piece of work. So, no? Yes, ma'am.
Earlier you mentioned that there are some issues to doing multiple copyrights at once. Is that something that would fall under the LLC category where you can say, like, I'm going to copyright so many things as an LLC?
So we could, whether doing multiple works under one copyright registration and how it relates to the LLC. So you can copyright multiple works in the name of whoever the copyright owner is. It could be owned by you personally, it could be owned by a company, it could be owned by the person you assign it to. The trick about registering multiple works is, for example, to register multiple works, they all must be by the same author and published on the same date as part of some larger whole. Right? So when we take multiple songs on an album, can copyright them all together, all on the same date, if they are all owned by the same owner, and all published together. When we have a series of paintings, okay, that were painted by someone and all first offered for sale at a gallery opening on the same day, great. But if they're put up on a website one at a time, once a week for a few months, can't be all done together. So these are the tricks. There's also an important part of your copyright registration. It'll ask you, is this work published or unpublished? That is a distinction that affects how you can group copyrights in a registration. Published is offered for sale, lease, or lending, or offered for the purposes of further distribution. So we have to determine when something is published and whether it's been published in order to figure out how we group those things. So again, it's a little tricky, but the rules are up on the website. So it's definitely doable. And related back to the LLC, your LLC can own your copyrights if you'd like. That is perfectly doable. It depends a lot of, it oftentimes depends on what type of work that kind of just, to the extent there is a norm for how we do these things. Different types of work, because a lot of times the artist wants to retain the copyright, you know. But oftentimes, for example, a book, you'll sometimes see the book is copyright in the author's name. Sometimes it's copyright in the publisher's name, right? So in that publishing deal, did the publisher get the copyright? So it does vary a little bit.
For a process, do you copyright a process or is that a patent? What's the difference?
Do you copyright a process or is that a patent? That is a patent. So patents, I should mention this briefly, because patent is a type of intellectual property. It covers inventions and business processes. And actually, to prosecute a patent, to do a patent application, you have to pass the patent bar, which is a whole other bar exam. You have to have a hard science or science background to do so. It's a very involved process and quite expensive, but certainly worth protecting your invention. If anyone's an inventor, you do have to patent it before you publish it or offer it for sale. So it's not saying, oh, I made this great invention, it's up on Etsy, and now I want to patent it. Not the way to do things. But it is, yeah, that falls more under patent.
I guess what would be more important? Let's say that like I come up with a series of stories, right? I know I'm publishing stuff, like self-publishing on the side, and I want to actually kind of make this a business. What's more important, the copyright registration or LLC? Like which comes first?
What's more important, the LLC or the copyright registration? Well, they're both important. Which comes first? So, common question that I get, and it kind of depends. Well, one thing, it depends. If the LLC is going to own the copyright, we obviously need to have the LLC first. If the LLC is going to be for publishing and distributing your copyrighted work, you can do the registration and then form the LLC and distribute it. But it really kind of just depends on the business. Yeah. Yes, ma'am.
Piggyback off of that. So if I sell a book and there's something in it that somebody says, hey, you stole this and didn't get the proper permission, whatever. You know, like, I don't know. And then I have an LLC. They're coming out for me, not the LLC, right?
So if you publish a book and there's some infringement in the book and you have an LLC, are they coming after you or the LLC? It depends on who owns the copyright and who's responsible for publishing the book. So if all of that is in the LLC, then we have argument for them to come after the LLC. If you self-publish and it's under your personal name, if you self-publish before you create the LLC, then yes, you can be personally liable. And again, you know, this stuff is not. I mean, if it's any kind of evidence of the fact that I don't, you know, see people getting sued all the time, I mean, I don't even do this type of work, and I can sit here and tell you the things to be afraid of. But the reality is, all this stuff is about kind of guidelines for how to run things and how to keep things in the back of your mind about, well, is this okay or is this not? I don't want you to think that everybody's getting sued every day all over the place, because that's not what's happening. And honestly, what often happens is you get a letter that says, hey, you're using that without permission, please cease and desist. Cut it out, all right? And maybe give me the money that you made off of that work. But very rarely is the first thing you get a lawsuit, because lawsuits are really expensive. And so, you know, again, it's not, the point of all this isn't to scare you, it's to help you create more consciously, I guess. And also, it's a lot of the questions I get asked all the time, so that kind of motivates what I've been talking about here. But to the extent that there are things that I didn't talk about here that you have questions about, I will always welcome your emails and phone calls. My contact info is at the bottom of that sheet. My business cards are on the table that you came by when you came in. So I definitely encourage you all to reach out if you have further questions. This stuff, like I said, is really fun for me, and I really appreciate all of you guys being involved in it and asking me questions, because it makes it a lot more interesting, I think, for you as well. I know we're getting close to time, so I will cut myself off, but I will hang out and stay a little longer if anyone wants to chat. And I will thank you all very much.
I want to let you know we really are appreciative of CBCA for making this possible. Dave, what a wonderful opportunity. You let us grill you for well over an hour, and we appreciate that. These are the kind of things that we like to bring forward for all of you so that we have meaningful exchanges. It sounds like with the questions that were asked, there was an awful lot of curiosity and good information exchanged. So keep in mind, if you have some other topics that you'd like us to cover, let us know that so we can bring relevant speakers as well. And let's take the last 20 minutes that we're in this room to finish off the food and ask Dave any questions you have and mingle as you'd like. Thank you so much for coming.